Thinking about defending an EOC charge or a lawsuit, I mean, we're talking about, $50,000 just to get through a trial. Not to mention the PR nightmare that can happen, right? You can have someone blasted, and even though the allegations may not be true, there's this perception that something did happen. So the best thing that you can do is have the right documentation, have the right training. A lot of times I see that medical or dental practices, they kind of grab something off the internet. There's so much that you can get online with AI and other tools. Or maybe they have a family member or a friend that practices in a similar area, and so they get a copy of their handbook. And I really want to try to advise employers to avoid that, because you could be creating more problems than helping yourself.
Hello, everyone. Today, we're thrilled to have Cherie Silberman, founder of Empath Law, joining us. Cherie is an expert in employment law, workplace culture, and compliance, helping businesses prevent legal risks and thrive. I've invited her to join me so we can discuss some common questions and topics I frequently come across with practice owners and administrators. Cherie, welcome. Why don't you tell us about yourself a little bit and your legal practice?
Thank you so much. It's great to be here and talk a little bit about the changing landscape in employment law. I've been practicing employment law for almost 20 years, and so there have been a lot of changes, and we'll probably talk about some of those today. But I started out my practice by defending companies of all different sizes and different industries and various different employment lawsuits. But after about 15 years of litigating, I decided I wanted to shift my practice to a more preventative nature. So I provide advice counseling for employers, and I do a lot of workplace investigations and training. So about 4 years ago, I started my own practice. I left a national labor employment law firm and started Empath Employment and HR Law. And that's where I do the work today. And I'm excited to be having this conversation.
Yeah, I'm excited to have you. So thank you for joining us, and we'll dive right in. We outlined a few things that just are really common, I think, that you see from what you do, but also, we work with practices and hear a lot of the questions or concerns. We see a lot of problems that occur regularly. So that's where this topic comes up. So I'm really thrilled to have you dive into some of these things. I think it'll be very helpful for people. Let's jump into the first section here. So preventing lawsuits before they happen. If you want to maybe give me a quick overview on that topic, and we'll dive in a few bullet points.
Sure, absolutely. So I'll start out by saying that I live and work in Tampa, Florida. So I'm a licensed Florida attorney, but a lot of work that falls under the umbrella of employment law is under federal law. So I can speak to that, can certainly speak to Florida law, but everything I'm going to be talking about today really applies to all employers on a national basis. We're not going to get into anything that's very state specific. In general, any employer really of any size in the country, to start with a solid foundation, they need to look at the bare bones policies. So do you have a good employee handbook? Because number one, that will include some legally required language and policies that you have, but it will also kind of set the framework for the policies and expectations for employees so that they know what to expect and know what to expect from the employer. So that's the first thing. And I will say a lot of times I see that medical or dental practices, they kind of grab something off the internet. There's so much that you can get online with AI and other tools, or maybe they have a family member or a friend that practices in a similar area, and so they get a copy of their handbook. And I really want to try to advise employers to avoid that, because you could be creating more problems than helping yourself. So let's start out with a good handbook, because like I said, sometimes there are provisions that are legally required, and it'll also have information in there that will help you. And we'll talk about that later on. So make sure that your policies are in good shape. And then more importantly is making sure that your employees, and especially the leaders in your organization, are trained on following those policies and how to handle it. So for example, let's say you have an employee that goes to a practice manager and says they can't work because they have a religious conflict. Or let's say they start talking about the fact that I have a family member that's sick and they're going to have surgery and they're going to be hospitalized. The manager needs to know what rights and obligations are triggered in that situation. So, do we have a situation where maybe there's Family Medical Leave Act that needs to be offered? Or is there a religious accommodation that the employer needs to offer? And those are all things that hopefully are set forth in your policies and in your employee handbook, but also that your leaders of the organization understand so that when and if they are confronted with this information, they know how to handle it.
Question for you. I've always thought I want to have an attorney, if not create, at least ratify the handbook that I'm going to use. But I know you can get these solutions through your payroll company. There's HR companies. What are your thoughts? Any reasons why that's a good or bad idea with a non-attorney solution?
I think it's a great idea. A lot of times it might be more cost effective if you have your payroll provider or your HR consultant or contractor that can provide you with a handbook. You just need to be mindful if you're making revisions to it, or if you have a multi-jurisdictional practice. Let's say you're in Colorado, but you have remote employees in California or any other state. There are a lot of state specific requirements that come into play. And so you may need to have a state addendum, or you may need to make sure that your employee handbook has the specific provisions for those states or even localities. There are some cities and counties that have their own requirements. So I don't think it's an issue at all to have a provider, a non-attorney provider, provide you with a handbook. And a lot of times those are excellent. But when you get to the part where you're making revisions that are specific to your organization, that might change the impact of the language in there, or you have other jurisdictions that whoever is preparing your handbook isn't aware of, that's where you need to make sure. And sometimes it's a good idea to have an attorney review that.
Yeah, because what happens if something was missed, you end up with a liability, and it was your payroll company. Yeah, I've always felt like perhaps having an attorney cover that. Obviously, I assume, but if something was wrong, you have malpractice insurance for that purpose, right? So that's been my mindset. Is that overly conservative on it? But
well, I know your philosophy is to protect the practice and make sure they're
yeah,
educated. So that doesn't surprise me. I think that that's a totally fine approach.
okay, great. And then lastly, a thing I know that I did when I was the CEO of a practice was I was really adamant, and I learned this elsewhere, was I wanted to make sure that I had proof of disclosure, that everyone had a copy, they signed for it. So not that I have it, but I can prove that they had it easily accessible, so I can always show that I was doing everything I could to follow the rules.
Right. Documentation is key. It's great to have a signed employee acknowledgement. And that goes for obviously employee handbook or policies, but also hopefully your organization is doing training. And we can talk about that as well, that every time you do the training, you have an employee sign off or at least some sort of digital record that they attended.
Yep. Great. All right. What's next?
Well, the type of practice that I have now, very preventative in nature. I do a lot of training. So I have to say that that is another area where employers and practices can really work to prevent a lawsuit before it happens. So investing in preventative education for all employees. And I always recommend having a specific training for managers and supervisors, anyone who's leading a team, who is a manager, who might have employees who report to them, because there are different expectations for managers in a company. They're really held to a higher standard. And when something happens, there's a different liability standard that happens. So it's really critical that they understand the policies of the organization and that they can actually enforce them appropriately. So training is a really big one. And then conducting audits to make sure that all of your documentation is solid. So that can be anywhere from an employee handbook, an offer letter, even background check authorization forms. That's another area where you can easily get into risk because of liability of using the wrong form or not using the right form, having too much language in a form. So really everything from pre-hiring an individual. And then if you kind of think through the progress of onboarding and other documentation that you would have, the training documentation in certain states, there's certain language that needs to be included in your harassment prevention program. So those are all things that if you have an HR professional or an employment law attorney look at your documentation, those are things that they'll be looking at, and making sure the policies are enforced. So it's great to have a lot of paperwork, but you need to make sure that there's an education on that paperwork and that the policies are being followed. So that's just kind of another area of where you can hopefully prevent some issues before they do happen. Education really is key. And then once you have those in place, then it's really important to foster a safe reporting culture, an environment where employees feel like, okay, there's something that doesn't seem right. I feel like either I or someone else is being treated unfairly, or there's something that I think isn't following company policy, that they know who to go to so that issues can be addressed before it turns into a lawsuit. I'm a big fan of that.
It's the best way to handle it, isn't it? I mean, so another thought that comes from that, like, I think business owners, practice leaders need to understand, when you've given an administrator, office manager some authority, how that reflects on you, right? Ultimately. So you brought up a mission point that they are at a higher standard. So if let's say the administrator of a practice says or does the wrong thing or handles a legal situation the wrong way, that ultimately falls on the owner, right? They can't just say, well, that wasn't me, I was an employee, because they were given that level of access or authority. Is that correct?
Right. Anyone who is a supervisor or manager, certainly that has any stake in the organization at that level, they're the eyes and ears of the company, which means that that's how the company is operating, and then they could create liability. So if you look at it from the perspective of, let's say, a discrimination or harassment claim, if the manager is aware that there's certain conduct that is occurring and they just kind of look away from it and decide not to take appropriate action, and something negative happens, then the company could be liable because as a manager, they're the eyes and ears of the company. The company knows about something and therefore they have to do something about it. So that's why I always go back to, and I may sound like a broken record, but why education is key, because it's great to have great looking polished handbook and documentation. But if you have a manager who isn't aware of the relevant laws and isn't escalating something appropriately, well, then you could be stuck with a potential bad situation, which could lead to liability.
Yeah, and everything's good till it's not. And I hear that a lot, that people probably don't take this as seriously as they should. But I can tell you, having been in countless numbers of practices and working with groups, you'd be surprised how many times legal issues come up for one reason or the other. So I do think it's something that if you're a practice owner, you haven't experienced this, don't assume that you won't or can't. I've seen things happen from nothing. I've seen things happen that are well-deserved because there was neglect. And I'm sure in your career, you've seen that even more than I have, but it is super common. It's not, to me, it's a high probability thing that you may encounter something. So I love this idea that preventing it before it happens. And we run that in our business. We're very documented. We're very on top of things. We make sure we cover ourselves. And also on top of that, when you mentioned a safe reporting culture, that can be tough in a smaller business, right? Mm-hmm. But you do need to create that channel and then take it seriously, document it. And then for us, it's all about follow-up and making sure that what we said was what they heard, that everyone's on the same page, that we're not just, it's a one and done conversation, but the problem continues. So we just continue to just follow up, ask if everything worked out. And I do that because I've learned, by watching what others have gone through. So I think your advice is well received from my experience.
Yeah, and I've heard the same thing, especially from small medical practices where, we're like a family and we've never had any issues. I don't think we're going to have any issue. That may be true. May not be true, but it may be true, right? But you're interacting with so many other people on any given day. Okay. You have vendors who are coming in that are bringing lab reports or picking up vials, or, just a FedEx or UPS delivery person, not to mention all of the patients that are walking through the door. Yeah. So you can have a situation where you have someone who's not an employee, but if that individual is creating a hostile work environment, harassing one of your employees, they still deserve to work in an environment that's free of harassment and discrimination. And it doesn't matter that it's not the employee who's engaging in that conduct. The fact that they're subjected to the conduct in the workplace triggers that obligation for the employer to do something about it. So it's not, a situation where it's like, oh, well, we don't have to worry about it because it's not our employee who's engaging in this conduct. No, you absolutely do, because the employees should not be subjected to that conduct. That's one real world example of, yes, you may have 7 employees who've worked for you for 20 years, and that is great. And hopefully you never have any issue. But those aren't the only people that are involved in the work environment that you have to be worried about.
Well, and I can't tell you personally how many times I've seen that person that I've known for 20 years later embezzles money or was fixing the PTO schedule for when they retire. So, and that the other part of it is, I think as a physician and practice owner, you also have to just realize the gap between you and the employees. They're really not in the same place you are. Even if you have a relationship every day, the reality is we assume most folks are going to be good and honest. It just takes one or maybe even two who collaborate together. But there is an inherent risk, in my opinion, when you have this kind of money or these resources and somebody who may not. There's temptation we've seen, there's lawsuits that have come from nothing. So I think it's really wise to separate and realize there needs to be a distance. And I know that's hard sometimes because you work shoulder to shoulder with these people and you want to think they're your friend. Doctors want to have their team over for dinner and stuff I just wouldn't do. I think there's too much opportunity for them to get too familiar. And I've seen people get blindsided by someone that they thought would never do that. So I think that calibrating your mentality towards the fact that you are not in the same place. You should keep a healthy distance. You should put barriers in place. And I would especially say, so my advice strongly to male doctors with female employees, I'd always want a second party or third party in conversations and try not to be alone with folks. So I found there's too much opportunity for things to go wrong, even though most people won't. So that's my personal experience.
Yeah, that's true.
All right. Anything else on that one before we jump to the next topic?
No, not unless you have any other questions.
No, I think that was very, very good advice. So the next one we'll talk about is understanding anti-harassment and anti-discrimination. So I'll let you lead us on this one.
I like to talk about harassment because it's widely misunderstood and it's something that everyone has to have a good understanding of what it means, what it looks like in the workplace. So the reason why is because a lot of times we hear individuals say that they work in an environment that's hostile work environment. Hostile work environment is actually a legal term of art that's equivalent to saying that it's harassment, unlawful harassment. So I want to talk a little bit about what a hostile work environment is, because that's not the same as what I would couch as maybe a toxic work environment or an environment where employees are not civil or there's bullying. Not to say that that behavior is okay and that it should be acceptable. But when we're talking about unlawful harassment, which is another way of saying hostile work environment, there's some key things that must be present in order for it to rise to that level where it's unlawful according to the civil rights laws that we're talking about. So first thing I need to do is explain what a protected category is, because all of these things that we're going to talk about, the conduct has to be related to or based on a protected category. So what's a protected category? It's race, color, religion, national origin, sex, age, disability, which falls under the Americans with Disabilities Act. There are different categories in different states that are considered protected. So for example, in Florida, marital status is considered a protected category. And then there are a variety of others in different states. So I needed to just define that term first, because there's a lot of behavior that I would consider to be inappropriate or unacceptable in the workplace, but it might not fall under the definition of harassment or hostile work environment according to the eyes of the law. All right, so first let's talk about what discrimination is. Discrimination is treating an individual, and that could be an applicant for employment or an employee, differently because of their membership in a protected class or because of an association of someone who's a member in a protected class. Everyone's in a protected class, right? Everyone belongs to some color, race, religion. So it's not that, I'm considered a protected class. Everyone is in a protected class. What we're trying to do is avoid anyone being treated differently in connection with the terms and conditions of their employment because of that protected class, right? So because of their particular age or because of their race. And by the way, age has its own federal law, which is the Age Discrimination and Employment Act. That's triggered when someone is 40 years of age or older. But again, there are some states that have different ages, or there's no age whatsoever, and it just says don't discriminate on the basis of age. Okay, so that's kind of the 30th view of what discrimination is. So I'm going to talk a little bit about what harassment is, at least how it's defined, and then I think probably will talk about some examples. So, harassment is verbal or physical conduct, either of a sexual nature or based on one of these protected categories, that affects the terms and conditions of employment and creates an intimidating, hostile, or abusive work environment. So these are things we're going to be looking at to see how often is this conduct occurring? How severe is it? Is it interfering with someone's ability to do their work because they're constantly under threat? Those are the things that a court or an EEOC investigator will look at to see if this conduct is perhaps just inappropriate or whether it rises to the level of unlawful harassment, aka hostile work environment. So I'm going to pause there, see if you have any questions, see if you ever get any questions or pushback on that.
Yeah, definitely. There's a few things, right? I know I've seen people, employees that might try to use this, in a way that just is more, I don't know how to put it, but creating an issue where there is none. They're trying to gain some leverage. They're trying to, I don't know, who knows? Maybe they're setting up an opportunity for loss, or sometimes they're just trying to, take some control of something internally. So things that, in my experience, I've seen, like, oh, well, this doctor swears a lot. In my experience, those types of things in themselves aren't problematic, right? So there is a line where, that by itself, I've advised employees, or like I said, well, swearing in of itself is not the problem, right? But is there an other issue? Are they treating you a certain way? And I thought it was interesting to have to teach employees that, like, to not feel like, maybe you're looking for trouble, or maybe you feel like you're being attacked or something for something that I thought was pretty mundane, but just kind of a reality. So I am curious your thoughts on some things that are probably unprofessional that aren't necessarily illegal. That's one example that jumped out in my head from experience that I've had.
That's where I go back to the employee handbook and the policies, because if you have an anti-harassment policy that defines what harassment is and talks about the protected categories, that's great. But I think it's advisable to also have a policy that talks about these other behaviors that you're talking about. So civility and bullying. Sometimes policies will define bullying. Sometimes it's hard to find the right terminology, but I think that you can do that, because at the end of the day, what we're trying to do is foster a work environment where people feel safe, where people are respected, and they're not engaging in behavior that violates that. And some companies do have policies that prohibit the use of profanity in the workplace. And to your point, just the use of a profane word, depending on what it is, and especially if it's isolated, likely won't rise to the level where it's unlawful harassment, right? Because we have to go back to, is it based on a protected category? Is it severe? Is it pervasive? How frequently is it happening? Those types of things to see if it's going to reach that threshold to be unlawful. But there's a whole lot of stuff under the unlawful threshold that I don't think should be acceptable at work. But company has to figure out where that is for them and how they interpret those policies. So it's fair to have both things. One is an expectation that employees aren't engaging in profanity, they're being respectful and civil to each other. Little caveat there's potential issues with the National Labor Relations Board, but we'll just table that for now. But for the most part, you can have, we don't want this type of behavior. May not be unlawful harassment, but we don't want this behavior. But also, here's unlawful harassment, and this is unacceptable. So I see that a lot. I do a lot of workplace investigations where someone's claiming discrimination or harassment. And then when you start to kind of peel the layers, you see, all right, maybe this is toxic workplace. Maybe this is bad managerial skills and communication skills, but it doesn't rise to that level where it's unlawful harassment.
Do you think now, larger organizations versus smaller, right? And I think when you see startups, small businesses, there's a lot more, people joke like HR violation, where in bigger company, I might be wrong with this. My gut would be to not put something so catch-all as a profanity clause or something that allows interpretation. And one of the first things that comes to mind, and I hear this from a lot of older generation, and I would put myself in there because I feel I'm from a different generation in the younger workforce now. There's a lot higher sensitivity, that I've seen in a different expectation, good or bad, with the younger groups. The tolerance level might be lower. So I would be worried that, okay, well, what was normal to me 15, 20 years ago, that's not normal for this group of workers today. And therefore, I would not want any interpretation or broad language or what is profanity. I would try to keep that a little more narrow, especially in a smaller organization, so that I have some control over it and don't get caught in a situation where someone gets really creative and saying that they felt, right? Because that's a big one. If I feel under attack, I mean, you can start to spiral from that is one thing that I worry about just from what I've seen. Am I overthinking that? Do you have any thoughts on that from like a generational perspective?
I think, well, we can talk about the generational perspective, but I do think that you have to be mindful that zero tolerance policies can be problematic.
Right.
And even these administrative agencies have said, it's a little bit difficult to have a zero tolerance policy. Why? Let's say you have a policy that says absolutely no profanity in the workplace. Okay. So what's
Yeah.
considered profane? I think we all can agree on probably a
Sure.
handful, but there might
Sure.
be some different interpretations. But let's say someone says something and it really isn't offensive given the context of it and it wasn't directed towards someone. Again, not to say it's okay, but if you have a zero tolerance policy, then theoretically the employer has to terminate that person. That's it. If it's
Right.
found that they did it. So what does that do? It chills other employees from making complaints about a situation because then they're concerned, gosh, if I say something, then all of a sudden, my coworker who really doesn't deserve it is going to be terminated and I'm afraid to complain. So that's the reason why zero tolerance policies are looked at with disfavor for that reason. So I think if you're speaking to that, I would agree with you that I don't like, and I think it's because I know the agencies disfavor it, having a zero tolerance policy. It
Yeah.
creates an environment where you won't have employees who report genuine problems and then you create this issue. Speaking to the generational piece, this is the first time we've had this many different generations in a workforce because we have
Right.
younger employees and then we have employees who, unfortunately, many of them are in a situation where they have to continue to work from a financial perspective. So we have a
Sure.
lot of different generations that handle things very differently. And I think you can't necessarily target or take an approach just to the younger generation. I think we need to do something that works for everyone. And sometimes that requires a little creativity and being mindful of it and understanding, okay, how does this 22-year-old take feedback? Very different than probably a 60-year-old.
Right.
And that's, of course, taking stereotypes into mind. But a lot of times that's true. But sometimes you have to have a conversation and say, hey, how does this work for you? What's your preferred method of receiving feedback? How do you like communication? Certainly for a bigger organization, they do these types of surveys to figure out what works.
Yeah.
So I think you're right, is to be mindful of it. I don't know that there's a one size fits all approach because of so many different individuals in the workplace now.
That I think you articulated it better, but that's what I'm getting at is I would be careful with catch-alls or zero tolerance because I've noticed, and look, I mean, the more extreme circumstances, I have noticed that difficulty with boomer, millennial leadership, and then Gen Z. And there is a higher sensitivity with the younger workforce, and I have seen accusations come a little more from that group. Things that maybe they're 100% right. By the way, I'm not even making a judgment. When you watch episodes of The Office, which are funny to us back in the day, you're like, whoa, like that wouldn't fly. But some of that's
Yeah,
pretty realistic for what we went through.
we've
But
learned. Yeah, we've learned a lot.
yeah, yeah. So I that's where I'm coming from, but I love the way you phrase it. I think that's exactly what I was getting at. And the generational thing is very interesting because they're very different behaviors with different employees, different places in their career. So yeah, I think the one of the last bullet points here is the risks of ignoring these complaints and allowing things to persist. Now that is a very common thing in small business, right? Because it's so personal. And that is a dynamic we work on a lot, and a lot of folks listen to us. Some don't. They don't want to change it. It's been that way a long time. The thing I think falls on deaf ears is the risk component. For me, I don't think the risk is small. I've seen it too frequently to think that it's unlikely. I think it's more likely if you let things occur that problems will eventually happen. But I'd love to hear your take on that, from your career perspective. What are the risks, and what do people need to know about that?
Right. So when I do harassment prevention training and I get questions on this topic of, well, what if it's just once and, it never happens again? Number one, if you're observing something that's happening, chances are it's probably happened before. It's going to happen
Yeah.
again. You may not be the one who's privy to it or aware of it, but anytime something happens that could create a risk of liability, or even if not risk of liability, something that you just don't want to happen in your workplace, that's the opportunity to intervene and do something about it. And it doesn't necessarily mean that it's something big and scary and there's this huge investigation, everyone's going to know about it. Sometimes it's just as quick as a conversation. And I think sometimes employees get scared that, oh, if I say something, if I do something, then it's going to all blow up. And managers need to know that that's not necessarily the case. But something's happening and, it's been allowed in the past. Our workplaces are always evolving. Our society and the way that we handle things, to your point about shows that we used to watch and stuff like that, just could never occur anymore.
Right.
That we're a little more aware of it and what is culturally acceptable and what's acceptable in the workplace. So just because something happened in the past doesn't mean it's not going to be a problem in the future. It doesn't mean that this individual is not testing the waters and seeing, well, if I can do this and no one's saying anything about it, well, I'm going to take it a step further. Because frequently that's how these things happen is, all
And
right, I'm going to just do a little bit, right? It's kind of like credit card fraud, right? Like they do $1 and you don't notice it. And then all of a sudden
yeah,
there's a bigger
dipping their
thing.
toe in.
Yeah.
I think you made a really good point, something that I talk about often, and to build on that. So if you're seeing it, I mean, people are pretty predictable, or, certain behaviors and
Sometimes.
indicators. You
Yeah.
know what I mean? Like, well, yeah, right. You can expect the unexpected, but truly, like, I think people's character shows, and the way they treat others, it shows. You can how they treat waiters, things like that tell us a lot. So if you use that idea and you see somebody, it may be great to you. Let's say I'm the owner. Every time I see, like, hey boss, how are you? And they're super nice to you, but then you see them, like, but then they talk down to others, or they're doing stuff. You should explore that. One of the things I run into a lot with practice owners is it doesn't happen to them if they don't want to deal with it, right? And or
Mhm.
they don't want to believe it's a real thing. And it's really hard sometimes to say, look, your experience is different than what everyone else in the practice is experiencing. So if somebody else is just unloading on other people, torturing them, giving them all kinds of headaches constantly, but every time you don't have to deal with that, that doesn't mean you should ignore it just because you don't have to deal with it. It's not fair to them. I don't think it's the right way to do it. It builds a toxic workplace. But that is where you can allow something to fester that eventually you will have to deal with. You either turnover, maybe a legal issue. And that is hard sometimes, especially smaller teams, for the owner to put themselves in someone else's shoes. Or it's that mentality of like, I'm busy. I don't have time for this. I don't want to deal with it.
Mhm.
It's like you have to have time for it. It will, in one way or the other, it'll work itself out, and it won't be positive if you're not managing it. So that's a constant conversation I think that we have, is trying to help with leadership coaches understand that responsibility. And aside from the liability, I think it's the right thing to do, because you want people to be happy at work. You'll have a better team, and it'll lead to better patient care. You'll be less stressed. So I think it all adds up.
I agree. And I get it, especially when you have a small team and it's easier just to push something under the rug and just cross your fingers and hope nothing happens. But that's why there are practitioners like me who can come in on an external basis. You can have an HR consultant and they can come in and provide some support. You can have an attorney to come in and look at things and provide some support. Yes, I understand that it can be a little expensive depending on the amount that you need, but you do have to look at, what is the risk if I'm not doing this, not just the legal risk, but to your point, providing the best patient care, what type of, bad press that you might get if you have someone who's disgruntled. So there are a lot of different reasons why you would want to do it. You want to create an environment where employees feel safe and that they're making positive contributions. And if you have a situation that is not taken seriously and handled appropriately, then that can just bring the whole thing crashing down.
Absolutely. Anything else on this topic? This is good stuff.
No, I don't think so. I think we'll probably talk about, some examples later on of what this might look like current day.
Absolutely. Well, let's talk about setting up a legal defense. That's the next topic here in terms of well, I'll let you dive into that. So what happens if we get past these other points, right, where we try to be preventative and stay on top of things? Let's talk about defending ourselves.
Yeah. Well, okay. So let's hope that we have some solid foundations in place. And if you need some external resources, maybe you hire an HR consultant if you don't have one in staff, because it's really important to have someone who's skilled in these areas to identify the problems and to see what happens. If you already have a legal claim, certainly getting your attorney involved. If you have employment practices liability insurance, notifying the carrier, and that those are some logistical things that you would do. And if you don't, hiring an attorney to look at some things to give you some advice kind of in a protected space where it's protected by attorney-client privilege, that's something that could really be helpful so that they can look at things without being afraid that it might be produced elsewhere. And so you can take preventative measures and also make corrections where it's necessary. I think if you have a claim and you can't do a proper investigation internally, either because you just don't have the bandwidth or because the allegations are against a physician in the practice or a chief level executive in the practice, you really want someone who is independent, who doesn't have a conflict of interest, who can conduct an investigation that doesn't have that level of bias. So making sure you're bringing in the right professional to properly look at everything and figure out what's going on. Really important to do that. And then, if you want some examples of how proper preparation can mitigate risk, a lot of times I see situations where an employee, they're complaining, they file an EEOC charge or, eventually a lawsuit, and they're claiming they were discriminated against or harassed. So if you have the proper framework in place, then hopefully you can show, no, these are all the things that we did to prevent this from happening. And then if it did happen, so that we could correct it. So a lot of times I've seen cases where there's an employee who perhaps they're terminated, they're demoted, or they're still just working in their same role, but they've gotten to a level where they're dissatisfied. They hire an attorney and or they file an EEOC charge claiming harassment or discrimination. And a lot of times they'll say, well, yes, I realize this is the first time you're hearing about it, but I didn't complain before because I didn't know who to go to, or I felt like I couldn't go to my boss, and you guys don't take this stuff seriously. So looking back, there are times where we could say, none of that is true. If you look at the employee handbook and you look at the acknowledgement and you look at the fact that we have, here are 3 different people that you can report something to, including as a bonus, let's say you have an anonymous reporting hotline, an external hotline so that people can reach out outside of the organization if something happens. That will really bolster your defense if someone's trying to argue that you didn't have the right framework in place for someone to report a complaint. So those are some things that you can have. Obviously, if you can show that they've been trained on the policy and they have a signed acknowledgement that they attended the training and that they understood it, even better. And then let's say you have a situation where someone is terminated for performance or for attendance infractions. Hopefully, you've set yourself up with proper documentation showing that they weren't performing, they weren't meeting their metrics, or they're showing their attendance infractions and that they've been warned about it before you take remedial action, or not remedial action, but before that you've taken any disciplinary action or terminated them, so that if and when they claim that, no, you didn't terminate me because I wasn't meeting my goals or doing my job, it was because of whatever protected category, you can show, no, it's because you weren't showing up to the meetings and you only met 50% of your sales goals for the last 6 months. So that will help you defend a claim to show, no, this wasn't discriminatory. This wasn't retaliatory. This was just based on legitimate business reasons.
Yes.
Makes sense, right? Easier said than done.
I think if somebody just looked at the bullet points of this, it'd be a no-brainer, right? The implementation is the hard part. And the hard part is like our process, which I think should be mirrored. Anything we do, we keep an HR file. Every communication is documented, whether it's small or big. It's part of our standard daily effort. Luckily, we haven't had too many issues. We had somebody in the past that stirred some trouble quite a bit, and I think we're pretty well convinced they were looking for an opening. And by all the documentation, the constant follow up, I think we gave no openings by doing it that way, because we didn't do anything. I mean, we were very good and patient, and when it came to working that person out of the organization because it was well deserved, we had to be patient, not rush it, cover our bases, because we were setting up for the future. If there was a legal issue, we kind of understand it. I think we understand it probably better than the average administrator or owner. But everything you were explaining there is kind of what I was doing and my wife, we run the business together, and she's our HR component. But we made sure that we covered ourselves, because even if we didn't do anything wrong, someone could take an opportunity. And I think we want to make it so that life is also easier. If we do go litigation, it'll be a lot easier to hand over a well-structured, organized HR file or documentation. And I think that'll save us time and money, and potentially could extinguish the situation. Just on the other end, just if they have an attorney and they're ready to go for it, and they look at stuff that's, maybe you have video recording documents, whatever you have. I mean, I think that could also cut things off at a pass. And then,
Right.
God forbid, if it goes further, I mean, you'll need all that anyway. So it's easier to make that part of your day in, day out, in part of your HR. And it probably also discourages a bad actor, because they realize these guys have their ducks in a row. And if we did something, then we'd be liable. I'm not saying this gets you out of trouble if you're up to no good, but I think the fact that we play a pretty clean game and try to do things by the book, I think it helps protect you a lot. And I do think most businesses are not doing that. I'm referring to small, mid-sized companies I deal with a lot. Probably as they get bigger,
Right.
it's more, they get proper HR. But so that's my
I think it's the
personal
right thing to do for the employee too.
yeah.
Let's say someone isn't meeting expectations. I think it's the right thing to do for them, even though it doesn't feel good. No meeting where you're providing discipline or giving corrective action feels good when you're doing it. And I know that's why a lot of times it doesn't get done, because it just doesn't feel good. But you're not doing anyone a favor, because at some point, if they don't improve their performance and you have to make a difficult decision and separate them from employment, it's right to give them an opportunity to improve. And it's also right to help the employer show that this is actually what happened. It wasn't because of these other reasons that the individual is now claiming. It's because of these things. So I think it makes sense overall. I think a lot of times I've seen that managers are doing annual performance evaluations, which probably should be done more frequently than that. Maybe not so formal, but so that people don't have to wait 360 odd days
Yeah.
to find out how they're doing. But let's say they do it once a year and it's, meets expectations, means it just kind of checking the box and not really giving any constructive criticism or feedback. And if that's what's warranted, great. I think they should get all fives, whatever the case may be. But if there's an area of opportunity and growth where someone is underperforming, that's when you need to have those conversations, even though it may be a difficult one to have, because again, you're protecting the company, because if you end up having to make the decision to separate, then you can show what was going on. And it also gives the employee an opportunity to know where they stand and improve. So I think that it happens throughout the course of employment, not just when you're having to discipline someone or put them on a progressive discipline, but even when you're doing annual evaluations, is be honest with it. Because if you're not, it's like no good deed. You're not helping yourself by being overly generous and kind when you have someone who needs a little bit more support.
Here's what we do. I think this ties into what you're saying. So from the time someone begins, they are given an onboarding checklist of all the things they're expected to do. And it's disclosed them that they're responsible to implement this, that they get the help they need. We have a schedule, because I want to show that we did everything in good faith, right? And we did our best. But they also give a skills assessment document. And on it, in the first 90 days, they have to check and sign off if they feel that they were adequately trained and given the right access. After 90, it states the expectation is after 90 days that they should be competent in these areas. And if they feel they're not, it's their responsibility. So we check in weekly, daily, of course, but it's really like a formal weekly check in the first 90 days to make sure we're on track. And then after that, we do monthly check-ins. Now, the reason I also like this is, there's all this discussion of like, well, it's a year mark, we do a review. Like you said, I think some people may go in soft on those, versus if we can look at month to month and rate your performance on specific skills specific to the job that match the job description, that they agreed with, understood their assignment, they signed off on it. Why I like this is when it's come to the point of termination, we really have had no conflict or anyone blindsided. I think if they leave a situation feeling like this was extremely detailed the whole time, I wasn't meeting expectations, it takes away a lot of anger, animosity. A lot of times there's no surprise. I think this is also like, I helped an organization that is, they've had this conflict with administrator, and I think it's come to a head, where the attorney contacted us and asked us for all of this and was very interested in the whole paper trail. And of course, what they're trying to do in that scenario is avoid conflict, right? We want to make sure the more we are armed and we've done this. So that's the legal side. That's kind of the unfun, almost unhuman feeling to it. But it's actually really good administration. It's
Mm-hmm.
good training. It's good for you to know where you need to help.
Mm-hmm.
I think you got to blame yourself first as a good leader. You need to go, well, this person's not succeeding. Is it my fault? Did I give them everything they needed? So this is acting in goodwill. And if you let somebody fester and underperform in a role, I don't think you're doing them any favors. I think if you learn to have tough conversations respectfully, kindly, upfront, proactively, you will be a better leader. And then it's going to serve this legal purpose. Everything you explained, I think the administrative side, the way that we approach it, the team building, the culture building, I think it all goes hand in hand to me. And then you're documented and you've got good evidence that you did good, that you weren't out here trying to create trouble for someone.
Yeah, I 100% agree. I think a lot of times a lawsuit or an EEOC charge could have been prevented if the employee wasn't blindsided. A lot of times it's just like, yeah. I got terminated. I never had any problems before. I didn't see this coming. It must be unlawful.
They're mad at that point, right? It hurts.
It's
embarrassing. Yeah.
Yeah, it's not good. It could have been prevented many times, I think. And so when you've got someone's job at stake, their livelihood at stake, there's a lot that goes into that. There's a lot of emotion that goes into that. And if you're making the decision, which sometimes has to be made, where you have to separate someone, at least give them an opportunity, unless they do something egregious. I'm a big fan, by the way, of termination. If someone is doing something that is egregious and it warrants immediate termination, you may need to do an investigation to make sure you know what you're doing and that you're taking the appropriate action. But sometimes you have to do that. But when we're talking about general performance and things that perhaps you need more training or you could be improved, then give the employee a chance, give them an opportunity. And then when it happens, maybe it's disappointing. Maybe they were surprised it happened that day, but it really shouldn't take them by surprise and they shouldn't be shocked. And I do think sometimes that does make the difference of someone running to an attorney versus just saying, all right, you know what, I'm going to pick myself up and move on.
Without question. Anything else on this particular topic? I think this is very good stuff.
Yeah, I think we're good.
Yeah. All right. So let's go. The next topic here is wage and hour compliance. It's a big one.
I know.
I'll let you lead us off on this and I'll chime in from there.
I know it sounds so boring, but it's so important. Yeah. It's so important. Yeah. So there's a lot to say on this. Basically, when we're talking about wage and hour compliance, basically making sure that everyone is properly paid. And the federal law that comes into play is the Fair Labor Standards Act, FLSA. So I want to talk about like one or two of the biggest areas where I think small physician practices can get into trouble here, because there's a misunderstanding about who needs to get paid overtime, how do we treat them differently, and why. And I think if we just kind of go over a couple of big areas, then it might be really helpful for business owners, for practice owners, physicians to understand. So let's just kind of talk about the basics, which is employee classification. Right. So there's someone who's considered exempt and then an employee who's considered non-exempt. So exempt means they're exempt from the overtime requirements of the FLSA, meaning they get paid a certain amount and they don't have to get paid extra for extra hours that they work in a week. Right. Non-exempt means they're not exempt from the requirement that they get paid overtime. So talking about exempt versus non-exempt. I think with the new regulations, they were trying to relabel this as like overtime eligible or overtime ineligible, because I think the exempt, non-exempt can be confusing for some people, but we're going to talk about exempt versus non-exempt. All right. So there's this common misconception that if someone is salaried, they don't have to be paid overtime. That's not necessarily true. So for someone to be exempt and they don't have to get the overtime, there are certain qualifications that come into play. They have to be paid a set amount, which again, salary is a way to do that. And they also have to be doing something that qualifies under the duties test. So either they're professional or they're executive or administrative professional, or they're highly compensated. But just because you pay someone a salary doesn't mean they're exempt. You could pay an office assistant a salary, right? Which is fine. It's fine to do, but it doesn't necessarily mean that that office assistant is exempt. If that individual is working more than 40 hours in a given work week, they're entitled to overtime for all the hours over 40. So that's just kind of a big overarching area where I see that there's this misunderstanding of the terminology, not just the terminology, but the way it kind of comes out in how it, the practices are treating it. So I will tell you that there are very few positions in a small medical practice that are going to be treated as exempt, properly exempt. The physician's exempt, your main practice administrator should be exempt because they're making, really important decisions, and they have hiring and firing and all of those things that would qualify either under the executive or the administrative professional or both. But licensed practical nurses are not exempt. An assistant in the back office is not exempt. Someone who's sitting up at the front, the receptionist certainly is not exempt. So what that means is you have to track their hours. And for all hours that they work over 40 in a work week, and we look at it on a week by week basis, they get time and a half their regular rate of pay. Seems easy. If you have, a decent payroll administrator and all the everything that's set up properly, that it's fine. But of course, you have to capture the right information, which means, if you don't have I know back when I was a teenager and working in a medical office, I had like the time clock where you could hear it and you punch it. And most often now you're logging into a computer or there's some other way of record keeping. Whatever it is, whether you're handwriting something on a log, punching a clock, or logging into a computer, you got to have some time record of the time that you're working. So you show up and you clock in, you clock out for lunch, assuming you get at least 30 minutes or more interrupted break, clock back in, and then clock out end of the day. Now, we know that sometimes people miss it and you can make a correction and that's fine. But it's really, really important to have accurate timekeeping and then to make sure that there's this proper classification so that if someone's entitled to overtime, they get it. So I've been speaking a lot on that already. See if you have any questions on that because I have more to share.
Yeah, absolutely. You mentioned keeping time. One thing that I know we've touched on in the past that I see a lot of is people that are hourly who, once they leave the office, will engage through text messaging, emails. And that's a problem, right? Once they're off the clock, they're off the clock. And that comes back to we had a policy to limit people's access on their phones if they weren't authorized, right? So essentially, are you salaried or not? Is it within the scope of work? I looked for, I remember the test that we followed, and I won't try to speak to who should or shouldn't be, but I felt like we did it by the book and we had our attorney time ratified. But the goal was if you were an hourly employee, you were in our handbook, it was clarified that you have no authorization to conduct business from your phone outside the office. Mm-hmm. If they did, we had to pay the time and a half, whether it was authorized or not, but then discipline for unauthorized overtime. Is that correct?
Happy to say you did it correctly. Right. That's right.
Yeah.
That's right. So you can discipline them for not following policies, but you do have to pay them for the time. And, if they become a repeat offender, then that becomes an issue going back to discipline. But the question is, are you training them, which I know in your situations you do, not to take work home, not to check email. Sometimes it's just easier to have the system so that they can't be checking their email from their phone. But, physicians a lot of times can pick up a phone and text, and maybe texting someone who's non-exempt and asking them questions. And that's where the education component becomes really important. And I see this not just from a working from home perspective, but in the office, right? So you've got a medical assistant who's back taking lunch, and you have a physician who's trying to figure out what's going on in the next case, or where did you put the instrument? Did you put it in the autoclave? Whatever the case may be. And they run back and they're not thinking about it, right? They're thinking about the patient and what they need to do and all of the clinical aspects. They're not thinking about wage and hour. I can assure you they're not thinking about the FLSA. So they're just going back and they're asking questions like, can you come up and help me with this? Okay, fine. That may be completely appropriate. But at the end of the day, that individual has to go and reflect on their timesheet that they worked that time to make sure that they're compensated for it. So there just has to be that understanding. Hopefully physicians understand that, but ultimately it's the employee who's not exempt who has to understand, look, if you didn't get your lunch break, then you need to go and do a time correction and we'll make sure that you get paid for that time. But that's where I see it happen frequently because that's the nature of the business. So if you have a practice
Absolutely.
where employees may not get their lunch, but it's automatically deducting an hour, that's a red flag because you need to make sure that, if they're not getting that hour break and they're working through it, it needs to go back into the time clock.
And are there circumstances where, like if somebody worked a 10, 12-hour shift, are they required by law to have breaks that they have to take?
So but it's going to depend on the state. There are some industry specific things. There are child labor laws that come into play. So it's possible. And this is where I would say check with your local attorney or HR consultant,
Right.
because there are certainly areas where in some states that you have to give them a break.
Yeah, I think you nailed it on the head. This is a super common issue in healthcare. I mean, a lot of some physicians take breaks, some work through the whole day, and they absorb staff, right? So the staff are going to might be trying to take a lunch break and it's pulled in. The other thing, a common scenario is people just like a rep will bring in lunch and people graze but keep working. So I do think it's a matter of defining what's acceptable. If someone's working straight through and they're eating and you keep them on the clock, probably okay in most cases, right? And that might be actually a really normal scenario.
Yeah, I think there are
So
some practices that do that. They're like, look, we have a lot of
yeah,
pharmaceutical reps come in. I don't know if they're considered working when they're sitting there talking to them, and I may want to ask them to do some paperwork and work on the charts. I'd rather just pay them all day, and that's fine. Just need to make sure that, if they're working long days at the end of the week, if it's more than 40 hours, hopefully the payroll system is equipped for this, but that it automatically turns into time and a half for the hours over 40. I think that's a pretty common practice because they just don't want to have to worry about it. They just want to say, the expectation is that you're here to work all day. If you happen to get 30 minutes, 60 minutes to yourself, great. But the
sure.
expectation is you're going to work all day and we're going to pay you all day. And
Yeah.
that's fine. I mean, FLSA does not require that employees get a break. But like I said, there may be, depending on what state you're in, what, other laws that come into play, there could be a requirement.
And with classifying these employees, I would say that it's very nuanced, right? In some cases it's real obvious, but
Mhm.
there's some roles that I would say it's worth clarifying your roster, what the positions are, understanding, because there are appropriate times. We've come into that where somebody's on hourly and it's a great deal for them, but it's not a great deal for the practice, and
Mhm.
they justifiably are qualified, right? And I'll give the advice that I'm going to give on that, but at the end of the day, I would strongly always default to, I know what I know, but I want an attorney that's state specific, the laws under control to tell me that I didn't mess that up. And that's always my default answer. Like I have a lot of experience in a lot of states, but I would never say that I'm the end all on that. I'm curious for you, like is there a resource you'd recommend if folks aren't ready to just go look at an attorney, but they want to kind of audit themselves or start to see where they might want to explore this? Is there a resource you'd recommend for practice owners and practice leaders?
Yeah, that's a great question because I'm a big fan of, free resources when they're reliable, just to at least get a start. So at least
Yeah.
the terminology, you know what you're dealing with. The FLSA does have an exemption kind of flow chart. So if you go to the Department of Labor wage and hour division, you can click through and kind of do your own test. Of course, it's only going to get you so far, but it'll at least educate you so that you can start to look at your roster and say, okay, well, here are some that are clearly non exempt, and here are some that are
Right.
questionable. And then at that point, I would find an attorney who's licensed in your area to take a look because these are really tricky. And to your point, there's especially under the administrative exemption, there's a lot of interpretation, a lot
Right.
of case law where, let's say, pharmaceutical reps, for example, wasn't clear. I mean, there's a litigation on it. And so really, it's going to depend on how the court rules. So you want to make sure, and that's why it's helpful to have an attorney involved because they can look at this under the cloak of the attorney client privilege to give you all of the information without a fear that, you're publishing this information to your employees. So it's protected.
Sure.
And then as a company, you can decide, what you're going to do from there, make the appropriate adjustments, communicate that effectively to your employees.
Administrative tip I'll add on this comes back to you having really good job descriptions and expectations. And then understanding what a rational workflow is or a workload for the day, because this is something we've seen people abusing overtime or people feeling that they're being exploited and they're being given too much work. Sometimes it is that the workload is unreasonable and you need to hire more. You need to know administratively when and how to make those decisions. And there's a lot that we do to create that. Also, I think I don't want to just tax people and wear people out. I think it's the right thing to do to say, I know what a rational workload is for this role. I know what it should pay. I know when overtime's appropriate. If you don't know those things, I think it's very hard to appropriately lead your practice and manage your team. And of course, then we get into potential risks for liability. But I think it all goes hand in hand, right? I mean, most of these laws are probably guiding you towards doing the right thing. And I think there's a lot more, whether it's deliberate or not, I think there's a lot of it going on where things are not being done by the book or the way they should be. I think it's probably a lot more common than people realize.
Yeah, and to be fair, I think a lot of employers aren't necessarily trying to skirt around the law or intentionally,
Yeah, I agree.
intentionally short someone from wages. Some of these things are really complicated. So you need someone who practices in this area because
Yeah.
it can be nuanced and the law's changing. I mean, there were regulations that were in flux with what was the minimum salary that an employee needs to be paid to be exempt. And over the
Yeah.
course of the last several years, I agree with you. Even if you're trying to do the right thing by your employees, you really need to make sure that you have this properly done because it's just a big area of risk. You don't want a DOL audit. I can tell you, you don't want a wage and hour investigator coming to your practice, interviewing your employees, asking you to produce payroll and time records and all of the employee documentation for the last 3 years. Not only is that disruptive to the business, it doesn't look good, and it could be costly. So it's just a kind of a ounce of prevention area where look at it, do the assessment, and just get it right so that you don't have to worry about that risk.
Absolutely. Best practices for timekeeping and managing overtime. Do you have some tips that you want to share with us?
I think we talked about a lot of them, which is educating the managers in the practice not to contact non-exempt employees when they're home and have them bring
Right.
work home or do work. Sometimes it's like, well, how could you be doing work from home because we're a medical practice and everything's here? But there's always, I was working on your
Yeah.
social media account at home and
Yep.
all of these things.
Exactly. Yeah.
Making sure that there's that proper understanding, obviously having the policies that tell employees that they're not allowed to work unauthorized overtime. Overtime is very costly. As I mentioned, it's time and a half the regular rate, and that adds up pretty quickly, especially if you already have someone who's working 40 hours in the office. So you tack on an additional 10 that they're claiming that their work, that adds up. And then let's say you get a
Yeah.
claim, then they're liquidated damages, which double that amount, not to mention attorney's fees and costs. So I think making sure there's the policy in place, there's the education in place, and that you tell employees, yes, we see that you did this extra work. We'll take your word for it. Not allowed. And you properly document that to make sure it doesn't happen in the future. So, I don't have a particular recommendation for a timekeeping system. As I said, there's a variety of different things. What I don't like to see is an Excel spreadsheet where it says 8 to 5 every day, right? Like that can't be
Yeah. Yeah.
accurate. Who shows up exactly at 8 and leaves exactly at 5 every day? Those are that's a red flag that I think a DOL investigator will look at and say, right. And there are ways of capturing this information. I know when I was defending these lawsuits for overtime, if someone's claiming I was here and there's so much technology now, whether it's on your car, whether it's on your key fob,
Yeah. Yeah.
alarm systems. So we have
Surveillance
that, but
cameras.
you don't want to be relying on it if you don't have to. Hopefully you
Right.
have pretty good documentation, but those are all some things to keep in mind.
Those are great tips, and I will acknowledge that this is a chore. I mean, this is why look, most practices kind of grow where the doctor starts and they get their first employee and they grow together. They put stuff together based on what they know how to do, and it gets a little wonky at times, but it works. And as you grow, it starts to show the instability of the foundation as more people come in. And it feels like a lot. It's really easy to not want to deal with it or think it's a non-issue, or and you're busy and you're really busy. So it is a lot. I'll now acknowledge that up front. This is not something you're going to just brush over and do the right way. So whether you're going to internally bring someone like Cherie in, or somebody who can help you sort through this, or you need to get your management team up to snuff, or you yourself as at least need to learn what you need to know, and decide who you're going to have manage this. It probably won't be you as a physician or practitioner. It almost certainly won't be. You just probably don't have the time and ability to do all this. I acknowledge that it's easier said than done, but it is extremely important. All right. Anything else on this topic? I think that was a nice coverage there. So let's look at the next topic here, is the importance of documentation. I know we've touched on this a variety of ways, but let's dive into this topic here. What do you got for me?
Okay, so you're right. I mean, we've talked about it quite a bit, about the necessity and the reason why you want to have a good handbook and policies. The reality is we may have expectations for our practice and for our employees, but if we're not communicating that, that's kind of worthless, right? How do we expect them to follow our guidelines unless we educate them on what they are? So that's just kind of pretty basic. But as I mentioned before, there are some provisions that are legally required to be included in your handbook. So just making sure. And by the way, you don't need a 100-page handbook. In fact, I detest those. No one's reading 100 pages, I can assure you. So get what you need in there, right? Make sure that it has the necessities, that it kind of reaches the right tone. I've seen some really fun handbooks that are done in a PowerPoint with some imagery, and it kind of has the language of the organization. It doesn't have to be, it can be just a black and white, Word document. And that's what I see 90% of the time too. So don't go overboard and think that it has to be extreme in a big treatise. It needs to be, reasonable, but 25 pages for a small practice is more than sufficient, in my opinion. All right. So just, not that you asked, but there's a little
No.
tip from the trade. Go ahead.
No, I think I know exactly what you mean. I've seen my preference is to make things as easy for all parties as possible. That includes, I've seen contracts, agreements that are like 30, 40 pages. And I want to make sure I'm not foolish, but I have found the simpler the documentation that people can digest, the better, while it should cover all the bases I need. So I laugh when you say that 100-page handbook. That's exactly where my brain's at, is don't overcomplicate it, essentially.
Yeah. I mean, there may be a situation for, executive and a physician that you need that much because you've got restrictive covenants and you have certain provisions, but for a handbook, that's just a general handbook. I don't think that you have 100 pages of things to say. Not only is no one reading it, but I think at that point you might be micromanaging, or you might have things in there that are going to create more problems than they're worth. And I'll give you an example, right? So for the Family Medical Leave Act, it comes into play when you have 50 or more employees within a 75-mile radius, right? I'm sure that you have many practices that do not have nearly that number. And so when I was talking earlier about, taking a handbook from, your med school, roommate, because you got it for free and you have a similar practice. Well, let's say you carry over an FMLA policy because all you know is, this works, right? You're not well-versed in employment law, you're a physician. So then you've got this FMLA policy, but you've only got 20 employees. And now all of a sudden you're creating a problem because you're telling your employees that you're going to give them 12 weeks of protected leave. I mean, that's nice if that's what you want to do, but is that what you really want to do when you're not legally obligated to, or do you want to create your own type of extended leave? So that's just an example of like what's in those 100 pages. So I digress. Anyway, but having the language that you want, creating metrics so that you can have the accountability, so everyone knows what the expectations are. And that, set forth the rights and obligations. There are some benefits, as I'm sure you know, of maintaining accurate and consistent records, right? So we've already talked about timekeeping records and making sure that those are accurate, not just that you're actually capturing the time, but that an employee is going back and making corrections or requesting corrections if the time is wrong. And then employee acknowledgments showing that they understood and that they were aware of these policies. So that if you're having these conversations afterwards, it's, you were aware, you signed off on it, right? And then I think we spoke earlier about the importance of having documentation regarding employee performance. If you do have to make a difficult decision to terminate an employee because they're not performing, hopefully that's not going to come as a surprise because you have that documentation in place.
Yeah, I mean, to keep it simple, I would say try to define every process in your practice so that it's not about one person.
Mm-hmm.
Like Susan has all the info and she's gone, we're in trouble. So in general,
Yeah.
realize if from the day someone starts, right? I want a roster, I want job descriptions. Into job descriptions, I would like a complete breakdown of what they are supposed to be doing. This creates expectations. It helps manage them. So on the front end, I also want a skills assessment document that helps me know what skills do they have and how do they score so that I can make sure that they're doing what they're supposed to or that I need to help them. Really, you're documenting everything in a way that is not reliant on any one individual. We should be able to take Susan out of the equation and put Jim or anybody else in, and the machine should still work, right? So if you want to simplify what should I be documenting, in my opinion, it should be everything. It should be all the things that I need to know and make sure that we're not just reliant on one person having their brain. And that's a good staff training, development, management, HR thing. And on the other side, right now we get down to the individuals. What am I documenting? The answer again is everything. But that's good. I mean, we're talking from day one. We've got the right employment agreement. They've signed. They acknowledge all these things that we expect of them, their skills, and that we're documenting each month. I mean, I like monthly check-ins. They don't have to be massive. It's like how we do this month. What was last month's goals? Did you hit it? Where do you need my help? And then anything disciplinary, the hourly, that we document that they got the handbook. So to me, I don't know that I could give you everyone a singular checklist that would apply, but I think when someone might be thinking, what do I need? I would break it down that way. I need everything documented, and it seems tedious, but if you start living that way and create it and have it, it makes your life so much easier. Your practice is more efficient. You have happier staff, by the way. If you look at it, I've got 3 kids. One thing I can tell you from the time they're tiny all the way up is fairness is immediately ingrained in them. And it is not different with adults, but with your kids, like if I give one kid an ice cream pop and not the other, there's a problem. Well,
Right.
that same rule applies in business with adults. I mean, there is almost a parental child relationship in that way, that they are looking to creating this continuity, creating this fairness, documenting it, making sure there's no ambiguity and that it's clear, actually creates more happiness in my experience. I think everybody's pretty pleased with that versus we're not sure what's going on. I don't know the process. Jim over here gets to do whatever he wants because he's the doctor's favorite. That's the stuff we want to take away. So I know it's a tough answer to say, what should I document? But I think that's my overview is it's everything. Think of every step and stage and find a way to document it so that it's not just about the one person who's been here for 20 years, right? It has to be about, can I put someone else in here tomorrow? And then the machine continues to work.
Right.
Not to oversimplify it and or overcomplicate it, but that's my answer.
Good rule of thumb.
Yeah. Anything else on the documentation side?
No, I don't think so. I think that, sometimes there's this inclination to think that documentation is so arduous, it's going to take so much time. But frankly, there are ways that you can simply send an email to document something. So it doesn't necessarily mean that you're pulling out a binder of all these forms every time you need to document something. Sometimes if you're just documenting a conversation, it can be a quick email or a note to the file, just so that there's something there so that a year or 2 or even more later, there's some reference and there's some recollection to it. So I think that maybe educating managers on that piece, that, just because I'm saying documentation doesn't mean that it needs to be scary or that it's
Right.
going to require
Hours
you
of work.
hours.
Right.
Exactly.
You're spot on. And you're just covering yourself. I mean, just don't leave things to chance because probably won't go the way that you want.
Make sure your documentation is good, right? Like, you don't want illegal documentation. You don't want to have, like I said, forms that don't comply. So all documentation is great as long as it's good documentation. If you're not sure, talk to a professional.
And by the way, with recording people and such, each state has its own laws, like with double or single consent. So I've run into that one too. Like, can I record my staff? Kind of stuff. I would say know what you're getting into. I like things that have timestamps and logs. A lot of the products we use in my business, there's a lot of timestamps I can't alter. That would help a lot if something went wrong to show like there's a log that was made 2 years ago and I can't modify it, but it illustrates that we did the right thing at the right time. So yeah, it doesn't always have to be, I've got a huge document brief that I have to fill out an hour afterwards. It can just be the little onesies, twosies that you're just constantly making sure you have evidence that you did the right thing.
Exactly. And good point about the recording too, is that, yeah, if you're in a two-party consent state, you're not taking audio recordings without someone else's permission. There are other ways to create documentation if you need to.
All right. Let's talk about real world scenarios and impacts. I think this is very interesting stuff. I think people want to hear about it. So what do you got for us?
I think that a lot of people can envision, all right, I know what unlawful harassment is. I know what discrimination is. And, if it happens in my practice, I'm not going to allow it. But I've encountered just within the past, the past several months in my practice, different scenarios where had there been, in my opinion, adequate training, then we wouldn't have gotten into, or not we, the employer would not have gotten into the situation that they were in, even though everyone's like, oh, yeah, we did training. So I'll give you an example. So there was a medical practice, relatively small, and there was an employee who made allegations of racial harassment. And she's a Black female, and she had complained about the physician making a joke that used the N-word in an acronym. And in doing the investigation and speaking to this doctor, he said, yeah, I said this joke, but it was really just a joke and it wasn't offensive. And it was just something that I had heard before. And I know it didn't bother anybody because if it did, she would have said something. So clearly it didn't bother her. So to me, that violates like a few of the principles that I do training on, which is just because someone does not complain, or even if they're smiling and laughing, that could be a nervous reaction and an embarrassed reaction. This is an individual who reports to you. You're the most senior person in this building. Doesn't mean it's okay, right? It doesn't mean it's okay for that person. And
they have to understand the power dynamic there.
Yeah, that's a huge thing, right? Huge thing. And even setting aside the power dynamic, let's say they were peers. That terminology, that language is not acceptable in the workplace. And she wasn't the only other person who was there. The patient was there. There were other practitioners in the workplace. Yeah, that overheard it, who witnessed it, who came up. And it just appalled me. Maybe it didn't shock me because I've been doing this for a while, that he would think it's okay because she didn't say she was bothered. To your point, there's a power dynamic there. If I'm a subordinate employee, multiple levels down, and you're the ultimate person in the office, I'm afraid for my job, right? And I'm not comfortable, and I'm a lot younger than you. In this situation, she was probably 4 decades younger, 3 or 4 decades younger. So to me, it's like, you can do training, right? And you can have policies. If individuals, especially, as I said, managers and above, don't understand this stuff, that, there's this concept of bystanders and there's this concept of people don't always tell you no, it doesn't make it okay, right? So fortunately, in that situation, she complained, there was an investigation. But I think a lot of other times, someone's not going to complain and no one's going to hear about it. And then, well, no one ever complained about it. And so it does it again, right? It does it again. So that's a recent example. Again, small physician's office and the way that played out.
Well, and that goes back to earlier what I said about, I think these physicians need to realize that these aren't your peers. They're not in the same place as you. They're going to behave in a way that is submissive, compliant, subordinate, and for you to assume that they are going to be entertained, or, to put it bluntly, they can't be your friends. Even if they want to be, or you might want to be, I don't think you can have that friendship with that power dynamic and everything else, the disparity in income and all the other components. So I think that's a good case study for what you went through to show that this person wasn't aware of, we are not in the same place and I have to behave accordingly.
Right. And that's huge. I don't know that physicians necessarily understand that. Again, not because they're bad people. They're focused on the clinical aspect. They're focused on their patient care. They're focused, somewhat on the aspects of the practice and, what they need to do from a billing perspective. But their focus is not on these Title VII laws and anti-harassment. And they probably understand, I probably shouldn't physically grope someone, but it goes well beyond that, right? Like they're probably like, oh, I know, how many times I've done training for a group of physicians that are like, I know what sexual harassment is. Okay, can we be done now? Okay. There's a little bit more nuance to it. especially with the way that our workplaces have evolved and the types of claims that are, being brought now. So,
Well, keep it simple. I mean, to me, I've always been fascinated by this dynamic. It's the only model in the world that I can think of off the top of my head, at least, that you have the highest educated and some of the highest earners working alongside people who typically don't have the same level of education, and certainly on the lower side of earnings, working shoulder to shoulder day in, day out. If you think of it that way, I think it explains a lot. And so if you aren't aware of that and understand it, I think what you might just behave as normal and what you think is just being friendly, and it can very quickly become something else for the other person and become a problem for you.
yeah. And I have no problems of, jokes and fun in the workplace, but there has to be some sort of understanding that if it's questionable, don't even go there, because you don't want to, it's the impact that it has on the individual and not the intent of the person who's engaged in the behavior. I know we were talking a little bit earlier about it's not just your employees who could create potential situations, could be your patients. There have been multiple cases reported, and settlements and verdicts regarding nursing homes or assisted living situations where there are nurses or medical assistants who are interacting with elderly patients who may not have, the same faculties that they had earlier on when they were independent, and they can engage in behavior that could arise to, sexual harassment. And the employer is responsible for safeguarding their employees and making sure they're not subjected to that type of conduct. And there have been situations where residents are groping and making inappropriate comments to individuals. And once the company is aware through management awareness, if they don't do something to promptly correct and make sure that doesn't happen again, there's potential exposure there. So that's another example of things that I've seen. It could happen in a regular medical practice, but I definitely seen multiple cases where it's happened in, in nursing facilities or assisted living facilities.
Any other fun case studies for us?
Well, fun, this one's a little over a year old, but I did find it interesting. So there was a warehouse where employees were blasting on huge stereo speakers on a forklift music from a couple different artists. One of them is Eminem. You're probably familiar with Eminem and
Sure.
his song "Stan," which it has lyrics in it that, normally listening to it in an everyday situation, probably you didn't really think about it. But in a workplace
Right.
situation, a lot of language in there that is vulgar and demeaning towards women. Fine. Okay. But what the problem was is there were individuals who complained about it and said, this is creating a hostile work environment. The people who did it were like doubling down. Instead of being told not to do it, they started blasting it, driving around. They were showing pictures that kind of like with graphic imaging. And making remarks and asking them, other workers to share pornographic videos in the workplace. So it was a combination of all this behavior, particularly once it was brought to someone's attention not to do it. It was like, no, we're going to do it and then some. And so there were individuals who brought a lawsuit, basically claiming this is discrimination, on the basis of sex. And at first the court said, well, no, this is offensive to, a man who complained and also to women. So it can't be discrimination on the basis of sex. And the appellate court said, no, we reject that defense. And, this conduct, it doesn't need to be directed towards a particular individual in order to support a harassment claim based on the allegations. It was repeated and prolonged exposure to this music with this type of language, in addition to, as I said, the other imagery that was basically saturated with sexual content, could constitute harassment based on this music. And so I found that case interesting because a lot of times, what's inappropriate in the workplace and then where does it rise to the level where it's unlawful harassment? That was the first case that I could recall of that nature where it's, and again, it wasn't just music, there were the other things, but I think for the most part, the emphasis on the fact that it was music was kind of eye-opening, frankly. And I think that it's important to understand that there are different ways that this can happen. As we're sitting here today, Super Bowl was recently, and there was a advertisement that Ye, or previously Conway, had up that directed people to go to a website that was selling T-shirts with a swastika. Horrific behavior, right? And I think
Wow.
a lot of people who are talking about this say, how could anyone condone that type of behavior when he's perpetuating would be hostile work environment harassment on the basis of
Right.
race, on the basis of religion. So in my mind, like if we're talking about like current day situations that could create exposure, create uncomfortable situations in the workplace, I think if someone had a Kanye West picture up on their desk right now, I personally, and I think a lot of other people that I know, regardless of race, religion, national origin, would find that highly offensive because what he's standing for. It's not just a man sexually harassing a female issue. And this is one of the points that I always try to get across when I'm doing harassment training. There's a lot of other conduct that falls under the spectrum of unlawful hostile work environment based on protected categories. And we need to be attuned to that and make sure that our employees are constantly aware of what this looks like, which is why I'm a big proponent of annual training. I don't think you just do training when someone is onboarded and then you check the box. Laws are constantly evolving. Like I said, way that we're seeing these cases play out with different interpretations, change in regulations. I think we're going to see a lot of different types of claims moving forwards. It's interesting. It's interesting work. I don't like that a lot of people that deal with things in the workplace that they really shouldn't have to deal with. They should be able to just go and focus on work. But unfortunately, I think there's a lack of education. And so that's why I do what I do and trying to investigate those situations, but also do training to make sure, employers are kind of equipped so that they can minimize or avoid those situations.
Absolutely. One of the last bullet points for me is, do you have any insights on the financial and reputational consequences of these lawsuits, or any consequences, pertaining to what we're talking about?
Yeah, it's a good question because I think most often as, physicians and practice owners, we're focused on that bottom line, right? Like what does the spreadsheet show? Obviously, the first is monetary, but there's more than that. But even just thinking about defending an EOC charge or a lawsuit, I mean, we're talking about, $50,000 to resolve it early on, up to multiple six figures, couple $100,000 just to get through a trial. And that's hoping, best case scenario, you win and you're out that amount for defense costs. So that's a big hit to the bottom line. But even setting the dollars aside, there's like a disruption element, component that can't be ignored. So whether it's a Department of Labor wage and hour investigator coming to your practice and going through everything, or having the physician have to stop and give a deposition and then show up and testify at trial, that's a huge business disruption, which again has a monetary component to it. Not to mention the PR nightmare that can happen, right? What is this going to look like in the news? We all know, I'm sure, I know, like the digital marketplace and Yelp and a variety of different ways where you've got a Google review and all you need to do is search up something and you can have someone blasted. And even though the allegations may not be true, it doesn't matter. When something is written up, there's this perception that something did happen. So beyond the financial consequences, there are a lot of others that you want to really try to avoid. And I do think that you can't avoid everything. I mean, there's going to be a situation where maybe a mistake is made, or maybe you did everything right, but someone's not
Yeah,
happy and so they make a claim. So the best thing that you can
absolutely.
do is have the right documentation, have the right training, follow through with that, make sure that the leadership is really walking and talking the policy and the philosophy of the practice. And that's the best that you can do.
I agree. And I think, you can liken this to HIPAA compliance, right? I mean, it's not even that you made a mistake. It's that you didn't disclose it, or you're not able to show history of being prepared and doing the right things. That's going to really get you in trouble, right? I think it's similar here. If you give a best effort and you educate yourself and you take the right steps to things you're supposed to, you're probably going to be in pretty good shape in most cases. If you leave it to chance, I feel like it's inevitable at some point something will happen. And I can tell you from my experience, not as an attorney, I've seen a lot more legal things that have occurred than you might have guessed. You would assume maybe it would be a little bit less frequent. So that is a caution. It's not a scare tactic. I think it's just being aware. Because I don't like that kind of liability. I wouldn't want to live through it. I've seen clients who got just financially punished, and I really don't think that they deserved it. I've seen others that probably brought it on themselves, to be honest, like things that could have gone better, been managed better. But other times I've seen where nothing was done wrong, and you're down 70 grand, before it's over. And I'd asked you once about, like, what if it's a frivolous lawsuit? Can you recoup legal expenses from an employee, right? And what was your answer to that?
It's rare. It's a high threshold.
Yeah,
You
right.
have to really prove that it absolutely was, but most often you're out.
Yeah,
And
that's what I mean.
yeah.
Yeah, so even in the best of scenarios, and unfortunately, I think even with all that, things can still happen. And the best way is from day one, your recruiting and onboarding strategy, really finding people and doing the best you can, and that gives you better odds. So that's my takeaway from all this. But anything else before we wrap it up?
No, I think, just kind of high level recapping. If your practice hasn't done any due diligence, and I understand it, you're starting out small and then all of a sudden you've grown and you never have an opportunity to hit the pause button and do all of those things.
Right.
It's never too late. And you can utilize the expertise of an HR professional or employment counsel to come in, and it doesn't have to be overly burdensome. You can just get a high level approach. And then maybe if you haven't, if there's some things that you need to do, you don't have to tackle them all right away. You can prioritize what needs to be done. So what I would hate to think is, oh, it's just too overwhelming, I'm not going to do it. And take the first step and,
Yeah.
just make sure that you have a good audit to know what you need, prioritize, and start doing things that will definitely help you in the long run.
And there are resources. I mean, that's what Cherie offers directly. That's what my company offers. Is you can't do all this by yourself. In reality, you might be able to early on, but as you get busier, it's unlikely. So finding those resources either internally or externally, very much a good recommendation. I know I'm a little biased with what I do, but I see it time and again, all aspects of your business, you're just going to have to get the right type of help. So figure out what that is. And if you need to ask and get some information on how to do that, there are resources like my company or like Cherie and others, but that's my personal tip, aside from the fact that I do own a company that handles that. Well, that's it for today's episode. I think this was phenomenal. I always appreciate your time, and I love talking to you about this, and it's been good knowing you over the years. So I want to say thank you for sharing these insights, and I'll ask you, where can listeners find you for any guidance, or what contact info might you want to share?
Yeah, thanks. It was a great conversation. I'm on LinkedIn, Cherie Silberman, and also my firm website is empathलाw.com. So it's www.empathलाw.com, and you can contact me there. So I appreciate the opportunity.
All right. We'll put your info at the bottom of the show here. And of course, if you want to learn more about how Numana Medical and Numana Digital can help you, we'll have our info below as well. Thank you, everyone, and we'll see you next time.
Thank you.